Howdy, I'm Keith Spencer with the Legal Hour from Bailey and Galyen, and today we're going to talk about immigration. Primarily, what does it take to get deported these days? Because it changes every day. And so I'm here today with Katherine Hawkins, who heads up our immigration department here. And we were discussing just before we started rolling how many changes have happened this year. It's a big year for litigation.
It sure is.
And all the rules seem to be changing on a daily basis. And you were telling me there was a big decision came down today that everybody's still going to have to digest and analyze and say, what does it really mean? Because with these decisions, it's not something that you can accurately describe in a 7-second soundbite.
Right.
Okay. So Katherine, tell me, let's talk about getting deported, because that's on everybody's mind and it's all over the TV. If I am undocumented, but somehow I have U.S. citizen children, can I get deported?
Yes, I think actually that's probably the easiest yes, because a lot of these maybe, it depends. But yes, if you do not have documentation, I think the media likes to call people illegal immigrants, but I prefer the term undocumented personally. But if you don't have documentation for your legal status, it doesn't necessarily change things if you have United States citizen children. It can make you eligible for certain forms of relief if you're able to plead your case in front of an immigration judge, but it doesn't make you protected from deportation as a whole.
What do they do with the kids?
So there's a lot, it's a big question, or it's usually next of kin, or if they have a United States citizen spouse, they'll have them stay with the spouse. And either way, the immigration judge is not making that call. Usually family judges in the area are making that call.
Okay. Well, let's talk about that for a second before we continue. You have the right to represent yourself in court. Mm-hmm. And the old line is the person who represents themselves in court as a fool for a client, because the judges have to treat you the same way they do an attorney, and if you don't know all the things that the attorney knows, like how to put evidence in, it puts you at a disadvantage. Do you find that too many people are going either without an attorney or putting their head in the sand saying, I hope nothing happens?
Yeah, I think it's a mixture of both. I think a lot of people feel as though they have some level of protection because they've been here for a long time, or because they have a stable job and they do their taxes and they have kids in school here and kids who were born here and they're a part of the community. And since they haven't done anything wrong, then they shouldn't be deported because they haven't committed any crimes or evaded their taxes or anything similar. And so they might put their heads in their sand about it, but it doesn't make them not deportable or being easily detained by ICE in these times where we're seeing ICE a little bit more frequently just out and about, especially in North Texas. And then there are people who can't afford attorneys because you have the right to have an attorney with you in immigration court, but you do not have the right to counsel to be provided for you the same way that you do for a criminal defense. So if you can't afford an attorney, you don't get one.
And that would put you at a pretty severe disadvantage, wouldn't it?
Yeah, especially if you're a child and you're not being accompanied by a parent.
Oh, okay, yeah. So if I have DACA, and we may need to explain what DACA is and if it still exists anymore, but if I'm a DACA person, can I get deported?
So the answer to this is also yes. It's possible to get deported if you've received DACA, but DACA status is protection from deportation, from most kinds of deportation in and of itself.
And that's what they're referring to as the Dreamers.
Yeah, the Dreamers Act. So typically these are children who were brought into the United States by their parents before 2007, or they have physical presence for 2007. They have to meet a very specific set of requirements to have DACA. But if you have it, you're not invulnerable from removal, especially if you are arrested for really any type of crime that, even if the crime itself doesn't make you deportable, deportation proceedings can be initiated if you are transferred from a criminal sector into to the ISIS system. I've asked for proceedings to be terminated based on DACA status, and immigration judges have said no in the past, depending on who the judge is and whether they think it merits a termination based on the crime or crimes that might have been committed at the time. But typically, people who have DACA, who don't have any violations, criminal or other violations, then they are mostly protected with the deferred action part of DACA.
So what's going on with DACA these days? I see it in the media a lot. And that's why I'm asking, does it still exist or not?
Yeah, no, that's fair. Right now, there have not been any official changes made to DACA. Litigation is ongoing, and so I just have been encouraging all DACA recipients that I come across to renew right at 150 days, renewing before that, 150 days before your card expires. If you renew before that, it risks USCIS rejecting it or returning it to you. But 150 days is kind of the minimum amount of time that's taking them to issue them. So the sooner you're able to apply in that window, the better, in case an adverse decision does come out, and you'll already have your application in, and hopefully those will still go through.
We're dealing with the government, and the single most frightening sentence in the world is, "I'm from the government and I'm here to help." It has been my experience that sometimes when I'm dealing with some of these government agencies, the turnaround can be a little slow on processing. Do you see any big processing delays that we're experiencing these days?
Yes, I think especially DACA is facing some big processing delays, where we were having about a 2-month processing time before. It's stretched to a minimum of 5, and some people are experiencing gaps in their DACA coverage, even though they put their submission, their resubmission in on time, and they're delaying biometrics being taken. But what I have seen is once they get your biometrics pushed through, usually the approval is coming relatively quickly. After that, that's just for DACA, though. It is not for other types of applications.
Okay.
Biometrics are not an indication of how quickly it's moving.
All right. If I have applied for my green card and that's pending, my application is pending, am I safe?
It's a similar kind of status as DACA. Actually, it's a period of deferred action, kind of, but really it's just like a period of authorized stay. So if your application is pending, your green card application is pending, maybe you got married to a United States citizen, and you're waiting on USCIS to give you an answer or give you an interview, you are usually safe from just general immigration enforcement. So if they see you walking on the street and you haven't done anything wrong, and they ask you to present your documentation and all you have is proof that your application is pending, they're not supposed to start removal proceedings. But, traffic violations, driving without a license, committing a crime, all of these, even traveling sometimes, especially if you're traveling within 100 miles of the border, put you at risk for initiation of removal proceedings.
Okay. If I have, here's some more initials. If I have a pending VAWA, U visa, or a T visa application, is that any kind of protection?
So there actually was a recent decision on this case over in a federal court on the East Coast. It's a ICWC versus NOAM. And that says no. If you have a humanitarian type of application pending, like VAWA, U visa, T visa, you are not supposed to be arrested or placed in ICE detention or ICE custody or removal proceedings while that is pending, because it discourages people from reporting crimes. U visa applicants are victims of crimes. VAWA applicants are victims of domestic violence. T visa applicants are victims of human trafficking. And if they are going to get arrested, if they have to go to an ICE check-in appointment, or if they are trying to fly to go see their daughter's wedding in a different state, then they're not going to report these crimes. And that's just contrary to the purpose of the humanitarian statutes that were drafted to create these types of applications. So the short answer, I guess, is no. You shouldn't be deported while you have these applications pending. But it doesn't mean you won't have to defend these types of applications in court instead of with USCIS.
What is a lawful non-immigrant status?
Oh, a lawful non-immigrant status is someone who is here on a visa, but it's a temporary visa. Students, for example, foreign exchange workers, tourist visas, people who are being employed for a short period of time, or just even a temporary time. We've got J1 visas are typically, we see a lot of hospitality J1 visas in the DFW area specifically, working at maybe the Omni, and they're from all over the world. It helps with tourism where they can speak the language of people who are coming to visit Fort Worth or Dallas. And then we have F1 visas, and they are typically university students or graduate students. And an OPT visa is kind of an extension of that, where they start a job after university and they have an extended period of time to work here. Tourist visas are obviously, they're visas for people to come vacation here. Employment-based visas can be anything from an Olympian coming to compete, in LA in 2028, World Cup players were here in the States, just recently on employment-based visas, on O visas probably. And all of these kind of have the same answer. If you are here on a temporary visa, there are ways to violate that visa. Every visa has its own specific set of rules. And if you violate that visa in a way that's super simple, like you're not supposed to drive, or tourist visa, you're not supposed to work. There was a controversy over this famous British Instagram or TikTok personality who toured here in the U.S. on a tourist visa, but he was making money streaming his touring, his touring of the United States, and that became a whole problem where he became ineligible to reapply for a tourist-based visa and has to do like a work-based visa if he plans on streaming or making content in the United States. So it can be something super innocuous like making an Instagram video that can get you placed in removal proceedings if you violate just like the tiniest, not very non-criminal, very non-violent situations. Even falling out of a full-time, I think full-time students in semester system are at 15 hours. So if you register for 14, then you've fallen out of your F1 status, and now you're in violation of your status, so you place in removal proceedings.
Oh, wow.
Yeah.
Well, during World Cup here, just this last couple of months, how many videos did we see of I'm tasting Texas barbecue for the first time? They don't have that in London, kind of thing. Yeah. And I didn't think about it, but I guess some of those people were making money on some of those.
Yeah, I think that the U.S. only, or it would behoove the U.S. government to only make a bigger stink about it if that is your primary source of income, like the man who was basically fighting his way back to the U.S. on a different visa, more than the Brits who tried Texas barbecue or Miko Sina's spicy margarita, right? Went to Buc-ee's. And so I think that's also why some of the soccer players were still able to make content. Like I think Erling Haaland became an overnight sensation, right? And I'm sure that he made social media money, but he was also here on a work visa
with a big cowboy hat,
shorts.
So if I have a green card, can I still get deported? And if so, for what?
Yeah. Okay. So this is a big one because I think that people forget that green card holders have lawful permanent status. Permanent status means permanent, right? They're allowed to stay. There are very few regulations that come with having permanent status. So they don't have the limitations of having to stay at the same job that an e-visa might have, or having to have a certain number of hours in their university. They can do everything that a U.S. citizen can do, except for vote or serve on a jury or say that they're a U.S. citizen. And if they want to travel outside of the United States, there's some time limitations that have to be considered. But other than that, they have the same rights as U.S. citizens. And I think that because there's a lot of freedom there, maybe lawful permanent residents can start to feel a little bit invulnerable to deportation. But that's not true. There are definitely deportable offenses, and even offenses that you might have committed as a kid, or like I say kid, not a juvenile, like in the legal sense of the term, but maybe you're 19 years old and you got hit with a controlled substance offense, and you didn't get placed in removal proceedings at the time because you were a lawful permanent resident, because times were different when you were 19, but then now you want to go to Bali to vacation, and you can come back in, and because of that controlled substance offense, the CBP officer, when you re-enter the United States, can place you in removal proceedings.
So if you leave, you can't get back in?
Well, they might let you back in, but you'll have to fight for your ability to keep your status and stay in. And sometimes you might get denied entry. It's really, there's a lot of discretion. That CBP officer, lots of discretion, not a lot of training, super fun combination. But it can happen where you could be denied entry. But other things they're almost all criminal events that can get you placed in removal proceedings if you are a lawful permanent resident. So like aggravated felonies, which there's a list of, I don't know, like 21 or 22 of them in the INA, which is the immigration law book essentially. And they are almost like they're violent crimes typically, or theft over 10,000, or they're the bigger crimes.
Right.
It's not for getting caught with a little bag of weed in your pocket. Actually, a little bag of weed, 30 grams or less, that's the only controlled substance offense that you can get a waiver for, even as a lawful permanent resident. So if it's a little bag of anything else and you get convicted, that's a controlled substance violation, and it makes you automatically deportable.
Okay.
And crimes involving moral turpitude, those are crimes that are morally repugnant. And if you think that seems hard to define, you would be correct. The formula for finding out whether something is or is not a crime involving moral turpitude that hasn't already been established by your sitting circuit, we're in the Fifth Circuit, everything's a crime involving moral turpitude in the Fifth Circuit. It's a long formula, but you have to worry about that more within the first 5 years of getting your green card. And you have to spend at least a year in prison in order for it to count for a deportable offense.
Okay.
Yeah.
Now, you've listed marriage fraud findings within 2 years of becoming a lawful permanent resident. I think there were some big actions taken in that area just in the last couple of weeks.
Yes. And so the way that they have been enforcing this is if you have been married for fewer than 2 years at the time that you receive your lawful permanent residence, if it was based on that marriage, then you have to file a second form. It's called an I-751 to remove the conditions on it. You get a conditional permanent resident status. It's valid for 2 years instead of 10.
Okay.
And then you have to remove the conditions on that card. And they kind of check back in to make sure that you really did get married to spend your life with this person. Actually, it can be any purpose other than marriage fraud. It can be for money. I've seen caretaker marriages where somebody married their nurse overseas, and that is I made the argument to USCIS that it's a valid marriage, and it was. And she got her permanent residence, and it was okay. But it wasn't a marriage for, like, it wasn't a love story marriage. It was a marriage of convenience and it wasn't for immigration purposes. It was because he trusted her and he didn't trust, didn't want to build that trust with somebody else in the States. So they check in on that with the I-751 finding. So if they find within those first 2 years that you committed marriage fraud, then yeah, you can lose your permanent resident status.
Wow.
Okay. Well, we've talked about all the folks who have less than full citizenship. Okay. And not everyone gets full citizenship. Not everyone wants full citizenship. Sure. They need to come here to visit family or to work on a job and things like that. But if they do become a naturalized U.S. citizen, are they out of the woods?
No. I mean, no. It's not really. If you naturalize, so there's two different ways that you can kind of, I guess, acquire United States citizenship. You can derive it from your parents based on a super specific set of rules, chart of rules, really based on your year of birth. And that you can't lose because you didn't have to earn it. Naturalizing, you almost have to earn your citizenship. There are requirements you as a person have to fulfill. You have to be in the United States for a specific period of time. You have to be an asset to your community and show that you're a person of good moral character. You have to pass a test, like a civics and history test. You have to pass an English test. You have to earn it. So that certificate of naturalization that you earn can also be taken away. And for criminal offenses, the United States only has 10 years to bring a course of action against you, to denaturalize you or take your citizenship away. And these are the big ones. These are terrorism.
Okay.
So there was a policy memo that came out in 2025 last summer when this administration started really pushing their citizenship new requirements, and not new requirements, but cracking down on citizenship. And it's like threat to public or national safety, war criminals, committing serious felonies before you acquired U.S. citizenship, but it was never disclosed and is later found out somehow or the other. So that would basically be like fraud on the government, right? Those who furthered the interests of gangs, committing human trafficking offenses, crimes of other crimes of fraud against the United States, or private individuals and companies, depending on the type of fraud and who you are, I suppose. And if you participated in government fraud or corruption in order to obtain citizenship, you can get it taken away within those first 10 years. But for a civil offense, there's no statute of limitations. Basically, the government, so this has to be through a U.S. Attorney's Office, not USCIS, not an immigration court or CBP or ICE. It has to be a U.S. Attorney's Office. They have to prove, they have the burden. It's like the only time in immigration law that the government has the burden and not you. They have to prove that it was a concealment or misrepresentation of fact that got you any status at any point that led to your naturalization. If they can prove that, which would take so much money, but that's what we're choosing to spend money on sometimes, then they will bring an action, and then they have to win it in order for you to be denaturalized. Yeah.
Where do you see things headed, and how important is it for people with questions to actually talk to an attorney rather than just Googling it?
Yeah, well, so the danger of Google is there's always been a lot of misinformation on Google, but now that we have the Google AI summaries, I think that the danger is a little bit more pronounced, because a lot of times the Google AI summaries are pretty good, and they'll list their citations. Those citations don't always say what they say they're going to say.
Right.
I've checked on it just to see.
Sure.
And so Googling is not always the most reliable source of information. Getting something from an attorney's page is good, but also attorneys can misunderstand or especially as laws come out and they're trying to put out content for their for their community to understand what's going on. There could be old information on that page where new information has since come to light and it's just incomplete, or it's moot, or something along those lines. And so attorneys pages, while they can be good places to start, attorneys pages that post links to the actual statute is even better, or the actual case law is even better. But if you don't know how to read those documents,
Right.
then you're gonna get in a little too deep, because there's only just so much you can copy and paste into Chat GPT for them to actually tell you what you need to know, and not just what you want to hear. And so even consulting with an attorney that can tell you there's nothing that you can do right now is better than spending a lot of money on someone who maybe isn't an attorney. I know that notarios and other people who don't practice law, but are do fill out forms of for immigration purposes, which is technically allowed, but it's a gray area in the unauthorized practice of law. But there are people who will take your money, and so consulting with an attorney will at least give you an idea of where to start, and what the right questions are. And a good attorney, in my opinion, will give you resources for a second opinion. I know that I do when I give information that I know that the person doesn't want to hear, so that they can feel comfortable hearing it from more than one person.
There you go. Well, the practice of law is interesting because we have general laws, and we have presumptions under the law, okay? And then 500 exceptions to those general laws. And so many times I have clients coming in and they're aware of what the general law is, but they don't understand that there are exceptions. And only someone who lives and breathes and digests all of this material could possibly answer for them.
And even those people have group chats to other attorneys trying to figure out if they think the same thing.
And AI, we're having a problem in the whole field of law right now, where many times people will write a pleading or an email, and it'll cite cases that never existed.
Hallucinating.
Yes, and it's a real problem where the courts are starting to require affidavits on the part of the attorneys that these are all legitimate cases, you haven't used AI to prepare your pleadings, that sort of thing. And I would also remind you that, like any other field, there are going to be really high caliber members of the field and newbies who just started, or sometimes people who are just not terribly careful. And it really helps if you find someone who has experience in that field. An attorney is licensed to practice almost anything, okay, but they may have never done it, and you don't want to be the guinea pig. So, Katherine, what would you suggest people look for when they're trying to find counsel in an immigration case?
My biggest suggestion is, if the person you're talking to can't break it down to bite sizes of information that you can understand, you're probably not a good match. It's going to lead to a breakdown of trust in the future. And so having someone who, I want to say speaks the same language, but that almost puts me at a disadvantage because I only speak English, but I have Spanish-speaking paralegals who assist me. But someone who can make sure that you understand what is going on in your case, where your case is at each stage, and where your case is headed, is going to be essential in making sure that you're comfortable, that you have trust in this person who is handling a big portion of your life for a while, at least. And I would definitely look for that. And for someone who also is willing to say, I don't know, but I have these are my resources. And like resources being a community of other attorneys who practice similar law, but maybe do it in a different area, or my practice is heavily like affirmative, and my defensive applications maybe only make up about 20% of my caseload, but my good friend who has her own firm mostly does defensive law. And so we have information that we encounter in our separate caseloads a little bit more than the other. And so we will communicate in that respect. And then there's people who are members of ALA, which is a huge network of immigration attorneys with resources like toolbox resources for like writing appeals if you need an appeal, or motions, etc. And knowing what their resources are. I actually had someone ask me that in a consult not that long ago, and he was the first one to ask me that in a long time. And I'm like, that is a really good question to ask. Like, what is your if I'm working as the sole immigration attorney at this firm, like who am I tapping into that maybe has more experience than me, or knows where this specific law is, where I can get my research started so that I'm not wasting billable hours trying to find something that's already been found.
Right.
Asking that question, I think, is a really good question to ask, and just making sure that you understand what's going on, and if nothing can move forward, understanding why. And if you don't, asking for a referral for a second opinion.
If someone wants some help, how can they get in touch with you, and what do they need to bring with them?
Well, if you have filed anything in the past, I would recommend bringing to your consult any communication that you have received from the court or from USCIS. And you can call or visit the Texas lawyer to schedule a consultation. It's $100 for a consultation to be placed on my calendar for in person, on the phone, or virtual, whatever is more convenient for you.
Thank you. This is Katherine Hawkins. She's our immigration attorney at Bailey & Galyen. And if you have any questions, there's no such thing as a silly question. And get a good answer, not what your friend at the bowling alley thinks he heard over beers the other night. This is the Legal Hour with Bailey & Galyen, and thank you for joining us.